Good afternoon. Thanks for being here today. Today is October 7th, and we are talking about ethical considerations in New York workers' compensation claims. Thank you for being here. If this is your first time with us, I hope that you are willing and ready to participate today. This is a totally live webinar. We do these live on purpose. And we do it live on purpose because I want you to participate. Please ask me questions. It makes this so much more fun when people ask questions. You can participate by typing your questions into the question bar on the GoToMeeting link if you're attending live. Now, I know a lot of people listen to these either as podcast or playback on video, and you're really depriving yourself of the most fun and interactive part of the presentation by doing that way. So please come in person. These are so much more fun that way. And please ask me any questions that you may have. You can type them in as I'm going along. I do only have about 30 slides to run through today as I cover the topics of ethics from the perspective of the claimant's attorney, and then the same looking at it from the perspective of a defense or an insurance company attorney. As I go through the presentation and as you're triggered and you're saying, oh wait, how does this apply or how does that work? Type your question into me, and at the end of the presentation, I will answer as many of them as I can get through in the time allotted. And you don't have to be just restrain yourself to questions about ethics, okay? There are a lot of topics, a lot of changes that you might want to ask questions about. Please feel free to do that. I love answering questions. I love talking about this topic, as many of you know. So let's dive in. Please remember that this webinar is being offered for instructional purposes only. I'm not giving advice as to any particular matter today. See your attorney for that. The goals of my presentation are to talk a little bit about what the ethical rules are in workers' compensation cases and which rules apply to us. And I know people go, wait, there's actually rules here? I go, yes. I mean, think about what's happening. What's the most interesting thing that's happening in workers' compensation in New York today? Well, these massive lawsuits that are pending accusing claimants' counsels of colluding with medical experts and their doctors, and in fact, filing false cases, completely false claims. So let's talk a little bit about the ethical jeopardy that those attorneys are in. So this is really quite timely. And I'm also going to talk a little bit about what's unique about being a defense counsel in cases where there is an insurance carrier and an employer. So I'm going to talk a little bit about that as well. So the source of the rules come from various sources, and it's important to realize that very few of these sources have anything to do at all with workers' compensation. The ethical guidance and rules that the attorneys that are participating in the system have to comply with generally come from the rules of professional conduct, which are included in the rules of court. So that's the general court rules. In New York, we call our civil court the Supreme Court, and that's where these rules are generally ensconced. There are some administrative code provisions which take those rules of professional conduct and basically lay them throughout the code. There are some case law, there's some decisions that I'm going to talk about today that also influence the way we practice law, the way we represent clients. I'm going to talk also about ethics opinions from the New York State Bar Advisory Committee. They issue opinions on questions. And by the way, I've actually asked them questions. So if you're a practicing attorney and you face an ethical conundrum, there is a hotline you can call in the state of New York and get answers from attorneys who specialize in just this area of law. And in some instances, they'll actually give you a written opinion or an advisory opinion, and that's where those ethics opinions come from. There are some workers' compensation law specific things that attorneys are expected to do. And the board itself, where we practice before an administrative agency called the New York Workers' Compensation Board, has some standards for civility that it demands that all practitioners comply with as well. And that also issues subject numbers. Subject numbers are really just memorandums that come from the board. Again, this is non-precedential, it's non-binding, but it does impact the way we interact with, for example, medical treatment providers. So let's focus first on ethical issues for claimants' counsel. And again, I'm going to try to make this as timely and relatable as I possibly can. First, We don't think about this very often, but in workers' compensation world, the attorneys that represent workers in general are not having them sign separate retainer agreements, or certainly not taking retainers in these cases. Instead, the inception of that relationship, where that relationship begins with the filing in court of the notice of appearance by the attorney, the OC 400. An attorney who has taken on a case in the workers' compensation context can withdraw, but that withdrawal must be approved by the workers' compensation judge. And that's what's been so interesting about the recent spate of cases claiming that claimants' attorneys and medical doctors and attorneys representing claimants in third-party or civil construction claims have been making up fake cases, fake treatment courses, fake medical records. What we've seen recently in our workers' compensation courts have been claimants' attorneys who are filing requests to be withdrawn as counsel. They're trying to step back from these cases. So this is a great real-life example of the application of an ethical rule or a requirement to what's actually happening out there right now. Right now, we're seeing in cases these being filed by claimants' attorneys, and it's just a few law firms at this point who are trying to really distance themselves from all of these workers' compensation cases that they have filed in the past. Now, the second rule I want to talk about is the Rule of Professional Conduct 1.4, which requires that claimants' counsel keep their client, quote, reasonably informed, close quote, about the progress of their case. And this means, and it's been interpreted to mean, that the claimant needs to know what's going on in their case, be reasonably brought up to speed, and be able to participate in decision making. Now, this is a rule that really is the source of most client complaints about plaintiffs' counsel. And why is that? Well, they just take on so many cases. They have got so many plaintiffs out there. They can't communicate with them at maybe the pace or the tempo that their client wishes they were communicating with them at, right? But I think it's also important for us to think through, particularly in the making of settlement offers, right? When we make a settlement offer to claimants' counsel, well, they have a duty to bring that settlement offer to their client and have their client make a decision about it. And I've actually had this experience. I think a lot of defense counsel have, and probably a lot of you out there who are adjusters or risk professionals who are making settlement offers. Sometimes I'll have an opposing counsel say to me, Greg, that offer is an insult. I'm not going to even take that offer back to my client. It's so small. How dare you? And I say, well, counsel, I just want to remind you, under the rules of professional conduct, you have to transmit my settlement offer to your client and at least give them the opportunity to make their decision about whether they want to accept it or not. And again, they'll say, Greg, that offer is so low, I wouldn't even bring it to my client. So you have to, right? So here's an example of us using an ethical rule to make sure that claimants' counsel is communicating with their own client. Now, this jurisdiction does allow pre-litigation contact to occur. Pre-litigation means no formal claim or filing has been made against the employer entity, and the plaintiff is allowed to communicate with them and perhaps obtain information or records to help them present their case. That's all allowed, but there are some limitations on that. First, those communications are supposed to be kept confidential by the plaintiff's attorney. And when they disclose information that they shouldn't have pre-litigation, they might be subject to some ethical issues. So all of those things are things to be thoughtful about. From the perspective of defending employers in workers' compensation cases, I'm always wary when the claimant goes out and hires an attorney, the attorney starts that represents the claimant starts communicating directly with the employer. They might be fishing for information that they would be otherwise not entitled to. And so as soon as you start getting letters or communication from an attorney representing a claimant, my advice would be, hey, you should be letting your insurance carrier know. And if you're self-insured, you should be probably speaking with counsel at that time. All right, contact with physicians and experts. We are in a workers' compensation world where we are always communicating with medical experts and sometimes with medical treatment providers, just run-of-the-mill things like scheduling appointments and making sure people appear for their necessary and curative treatment. And it's okay to have some of that communication, particularly where it's limited just to scheduling an appointment or approving an appointment or making a payment. Where it becomes problematic is where the attorneys or any party is trying to direct and control care or influence the medical opinion of a physician. This is specifically disallowed in the rules and they're in the statute as well. The same thing with expert physicians who will be performing an independent medical evaluation of the claimant. There are strict limitations on what kind of communication we can have with them, and all of that communication has to be disclosed and the other party should be present for it. What this means, essentially, is that when we communicate with our medical expert, we need to be communicating with them only by utilization of letters or emails. We want to put everything in writing, and we're going to communicate in such a way that we're copying opposing party as well. But remember, these same restrictions apply to opposing counsel as well. So communicating with physicians and experts is also disallowed by the claimant's attorney. They are not supposed to be directly communicating with the medical providers, asking them their opinion, trying to persuade them, do any of those things. And does it happen? It absolutely does. So we have to be very careful about that. In my practice is that when I have a treating physician on the stand and they're being deposed, maybe it's their deposition, one of my first questions is, has anybody communicated with you about today's testimony? Did you prepare in any way? Did you have any sessions in which you rehearsed or reviewed your testimony today? And who did you have those conversations with? And most of us as seasoned practitioners know that this is specifically disallowed. But sometimes people don't observe it, and I'll give you a few examples of that in the next few slides. But it's really important to ask those questions. Doctor, what relationship do you have with the claimant's counsel? Have you communicated with claimant's counsel on any issue? Do you have a financial relationship with claimant's counsel? And what is that relationship? Are they communicating with you about this particular claimant's treatment course? Or any claimant's treatment course? Those are all fair questions that should be asked in the preface to the deposition. Now, there is a significant penalty for this influence. If a party is found to have been contacting a healthcare professional, communicating with them in any way, well, all of the records of that professional might be thrown out of the case. So where we discover that the claimant attorney has been communicating directly with the medical provider, talking about the treatment course for the claimant, asking questions about that, trying to be persuasive, that's a wonderful opportunity for us to challenge whether or not that medical professional's records should come into the courtroom, because I don't think they should. I think they've been tainted. On the same token, we can be precluded from cross-examining people where their evidence has been precluded. And what that means is they can't get the medical records thrown out for undue influence or improper communication, but then say, Judge, okay, I understand all these medical records have been thrown out, but I still want to put that doctor on the stand and ask them questions. Not appropriate, and we should challenge that. Now, I've had personal experience with this. Here's a very clever and interesting case. It's a board panel decision, and the case is called Paksinski. And I have a citation here up on the board for anybody who wants to go look it up. But what happened in this case is that I put the treating doctor on the stand, and I started to ask the doctor a few questions. And I said, Doctor, were you ever contacted by plaintiff's counsel or claimant's counsel? He said, yes. And I said, what was the subject of those discussions? He said, well, he said, you're going to, he told me you're going to be deposed and you're going to give some testimony. And we talked about the subject of my testimony today. I said, Your Honor, I'm going to move to have all of this excluded. Well, opposing counsel was pretty clever. And opposing counsel said, yeah, Your Honor, but that did happen, but I'm allowed to talk to this treating physician. And I'm allowed to because I don't just represent this claimant in a workers' compensation case. I also represent them in a pending civil action that stems from the same accident. So in other words, I have a dual role right now, Your Honor. I represent the claimant in a workers' compensation case, but I also am the plaintiff's attorney in a civil action against a different entity. And so when I was communicating, Your Honor, with this doctor, it wasn't about specifically this case. It was really about the medical treatment that was going on in the civil action. By the way, they're the same accident, so it really is the same treatment. And by the way, Your Honor, in the civil case, in the civil world, and under the civil rules of procedure, I'm allowed to do that, right? So that's a pretty clever, I thought, argument as to why they should be allowed to do this thing that really our workers' compensation law says is undue influence and disallowed. Well, I argued to the judge. I said, that's ridiculous, Your Honor. There's a lot of situations where there's dual representation going on. That doesn't mean you get to sidestep our workers' compensation rules. This doctor's been tainted, their testimony's been tainted, and Your Honor should throw it all out. And the judge agreed with me. The judge said, you're right, Greg. They shouldn't be allowed to backdoor in influential or persuasive conversations with the treating physician by saying, oh, I was wearing my different hat. I was the plaintiff's attorney in a civil action when I had that conversation, because it clearly impacts the workers' compensation case. Okay, so that happens, and you need to be careful about that. All right, a couple more general ethics rules that apply to claimants' attorneys are those involving conflict of interest. They're pretty rare for them to have a conflict unless they previously worked as a defense counsel or defended the employer, or have some sort of relationship with the employer that would have put them into privy into information that was useful for them in prosecuting the claim on behalf of the workers' compensation claimant. So again, relatively rare. Now, the last ethical duty that I'm going to talk about is the duty of candor, and it applies to all parties, but it also applies to claimants' attorneys. Nothing gets me angrier than when I feel that opposing counsel is either coloring the truth, concealing something relevant, or telling a partial truth to the judge of compensation. Where I believe that is happening, and where there has been a concealment of a relevant fact, or maybe bringing up testimony that I think has been tainted, it is my duty as an attorney, regardless of who I represent, it's my duty as an attorney to stop the proceedings, address it with opposing counsel, and bring it to the attention of the judge. That is a duty of professionalism that I owe to the bench, and I owe it to the bar. I took an oath that says I'm going to do that, and I'm going to always challenge if I think there has been any unethical behavior on the behalf of a claimant attorney. So that's a duty that we never, ever abrogate, and we always retain. And it applies to both sides. If the claimants counsel has a duty of candor and honesty, and they should call us out on it. They feel that we are doing something that challenges a rule of ethics like this. All right, let's shift focus now onto ethical issues that impact us as employers' counsel. First, let's talk about this unique relationship that we have, which is that we have what's called a tripartite relationship. In many of my cases, and we're defending thousands of them here at Lois Law Firm, literally thousands of cases get referred here a year that we are defending, many of them by our insurance carrier referral partners. And we love you people. We love you. We love you. We love our insurance carrier referral sources. But when you refer me a case as an insurance carrier, you're actually referring me a case that is going to have two parties that I represent, two masters. I'm going to represent the insurance carrier, but that's always my second master. The first master is actually your insured, the respondent or the employer. We call them clients here. That's who we really defend and owe our highest level of obligation to. And this can be a challenge, right? Because some of our referral partners might send me hundreds or maybe even 1,000 cases a year. And you could look at me and say, well, I'm spending a couple $1 million a year with you, Greg, every year on defense. We've got this relationship. And I go, yeah, but you're always going to be in second place to whoever the insured or the employer is. And that's the rules of ethics. There's decisions that go back on this almost as all the way back to the beginning of the workers' compensation law 100 years ago, more than 100 years ago now in New York. The earliest case I could find that talks about this duty is in the case of American Employers Insurance Company versus Global Aircraft. This is an old case from the 1950s, and it said, quote, one counsel, although paid by the casualty company, undertakes to represent the policyholder and files his notice of appearance, he owes to his client the assured in undeviated and single allegiance. His fealty embraces the requirement to produce in court all witnesses, fact and expert, who are available and necessary for the proper protection of the rights of his client. It is immaterial that such procedure increases the cost of the carrier beyond the policy coverage limits. In other words, that duty of defense and my ethical obligation to present a complete defense comes first, comes ahead of everything. And there's also case law that says that even where we exceed, or where the cost of defending the case exceed the policy, that duty of defense that the insured is owed has to be vigorously supported by me, the defense counsel. The insured is my first client and therefore deserves my total fidelity. I am unable to offer any assistance to an insured that I think would abrogate that first duty. So even though I am retained by the insurance carrier, my duty has to be to that entity that I represent, which is the insured. Defense counsel are prohibited by rules of professional conduct and ethics opinions from entering into any agreement that limits the ability of the attorney to represent the insured fully. So this is a challenge, and we have to be thoughtful about who we represent. I owe the duty of accurate counsel and a duty of self-abnegation. That means putting my client before me and my interests to that employer client. And there are case law and model codes of professional responsibility that repeat this. And it's really been something that it's something we have to be mindful of. And in our workers' compensation context, actually, it's interesting that the board refuses to refer to employers as employers. They always refer to them as carrier. If you read their opinions and decisions that come out, almost always either says self-insured employer or carrier. But there, that's something that we approach every day. We have to approach it very carefully, and we have to be very thoughtful about that. We want to present the most aggressive and complete defense that we possibly can for our insureds. That's what we owe them. Now, interestingly, the workers' compensation carrier can settle claims without the consent of the insured, unless that right is specifically reserved in an insurance contract. And in general, I've never seen that. And that's because most insureds, let's be frank, want as little to do with the workers' compensation system as possible. And they are expecting that the insurance carrier is more sophisticated and has more relevant knowledge and experience and is able to settle these cases efficiently. In regards to settling cases, whether or not the insurance carrier wants to, it is compelled to disregard its own financial interest to make sure that the insured is covered. And I will say, I'm very proud to say that the clients that we work with never really have ever come close to suggesting that or pushing that. As a defense counsel, I can tell you I do feel very unfettered by the financial considerations of my clients in reaching an amicable resolution or settlement in cases. Legal billing guidelines are one of those interesting areas where if defense counsel is presented with them, and if they prohibit or prescribe or limit the defense counsel from being able to present a complete and thorough defense, defense counsel should reject those billing guidelines. Now, in general, we don't see that, although I have seen some guidelines that attempt to limit how many hours a day an attorney can work on a specific case, or how many hours of work a day a defense counsel can work for other unrelated clients. Those things are obviously impairment of the defense counsel's opportunity to serve other clients and obviously violate these rules of ethics. Another challenge that comes up in our context is where an insured seeks directly from us, the workers' compensation counsel, questions that exceed the workers' compensation arena or go outside our jurisdictional boundaries. I can give you a lot of great examples of this, but it comes up in the context of like 2 or 3 things that come up a lot. First is separation of an employee. Second thing would usually, where it comes up, is things involving drug testing and maybe some employer remediation. They're going to put someone on a professional improvement plan or something because they violated a work or safety rule. And then the third thing is sharing records. So let me talk about each one of those three common scenarios that comes up. And first is separation. I do get a lot of questions about when and how they can separate an employee who has brought a workers' compensation claim. And I always say the same thing. I say, look, under section 123 of the Workers' Compensation, 120 of the Workers' Compensation Act, you're allowed to separate someone while they're collecting workers' comp benefits or after they've made a workers' compensation claim, but it can't be discriminatory. You can't separate someone simply because they filed a workers' compensation claim against you. I get it. You're annoyed, maybe. Maybe you think the case is not real or it's fake. But you can't separate them for filing a workers' compensation claim. That is per se discrimination. And I've actually seen cases where employers have sent them a text and said, if you file this case, I'm going to fire you. And then they file a workers' comp case and they get fired. I mean, that's per se discrimination, right? So our statute does not allow that, does not condone it. And there will be penalties that will be assessed directly against the employer for doing those things. And those penalties could be things such as restoration of job, restitution and lost pay, and then penalties against the employer as well. And by the way, all those things are not covered by your workers' comp insurance, so don't do it. But employers come to me and they say, Greg, can I fire this person? I need to fill the role. I got to terminate this person and get the new person in. I go, absolutely, you can do that. The law does not say just because someone files a workers' compensation claim against you that you have to keep their job open for them forever. No, if you have a role and you need to fill it, you can go and fill it. So, we will give advice as long as it's within the boundaries of the workers' compensation law. You're asking me the question about termination and the impact on the workers' compensation case. I will tell you, if you terminate someone, it's going to impact the workers' compensation case because now you're not going to be able to offer them light duty assignments or accommodated work, right? So, we'll guide them through that. And that's all fair. But where it starts getting into, and how should I fire them? What words should I say? And whoa, now you've got me, you're asking me to become your employment practices lawyer, which we are not. We don't do that here. So that's the first context. The second context that it comes up in is where the employee maybe violated a safety rule at the time of the workplace loss. After the accident, we discovered, hey, they weren't wearing their hard hat. They weren't wearing their safety glasses. They weren't wearing their safety boots. And maybe their accident is worse because they violated a safety rule, right? And the employer will call me up and say, okay, I know you're defending us in the workers' comp action. We want to do, we have an issue with this employee and it's because they violated a safety rule and we're going to terminate them, or we're going to dock them pay, or we're going to demote them. Okay, but those things have nothing to do with the workers' compensation case, and I really should not be providing you advice about those things. Another context that comes up in is the failed drug test, post-accident drug test. After the accident, we did our urine toxicology. We discovered there's a drug issue here, and we're going to sever them because they violated our zero tolerance workplace policy on specific enumerated drugs. And I said, okay, great, thank you for letting me know. But they weren't intoxicated at the time of the accident. There's no allegations about that, and certainly the toxicology doesn't show that. So that's completely separate. That's an employment decision you're making, but has nothing to do with what I'm going to do in the workers' compensation case. And I'm not going to guide you through that because, again, that exceeds the boundary of my workers' compensation responsibility to you. The last thing that comes into play is sometimes the release and resignation. We want a resignation from this employee. In those instances, and where they have an insurance coverage, we will generally open a separate matter. We'll be separately engaged to do that because releases and resignations are really not appropriately paid for or resolved under the workers' compensation claim. So I hope that's a little bit useful about the context where this comes up, where representation exceeds the workers' compensation contract. Now, defense counsel also owes a duty of candor towards the tribunal, and of course, we think that there is plenty of meat on the bone. We do not have to get even close to the edge of concealment or fooling or tricking or lying to a judge. That's just not something we would ever do as your attorney. It also means that when we sign documents on behalf of our client, those could be considered sworn pleadings, and the attorney themselves could be liable for any of those violations. I have a duty, an ethical duty under the Rule of Professional Conduct 3.2 to cooperate and to be in communication with opposing parties. My job is to move this case forward and move it to resolution, and I have a duty to communicate with opposing counsel. Now, I'm also not supposed to engage in frivolous litigation. That's Rule of Professional Conduct 3.4. That means adventures, that means trying to paper people over with nonsense discovery demands, etc. And in general, this is not a challenge. However, this is one of the most frequently brought up arguments by opposing counsel, where they'll say, Greg, we're going to sanction you, or we're going to come after you. You're engaging in frivolous litigation. Those are usually just positional threats that are being made for tactical purposes by opposing counsel who are making an effort to try to pressure towards settlement. And of course, we don't engage in those types of behaviors. All right, so a couple takeaways before I jump into your questions. And if, by the way, you haven't typed your question in yet, please do so now because I'm about to get into the questions. There are many sources of ethics rules in New York. Some we might not have ever even thought of as applying in our workers' compensation context, and some that are very specific to the workers' compensation context. Certainly, the issue of undue influence or communicating with a medical professional, that's very unique to the workers' compensation system in New York. There are some non-binding sources of ethical guidance, such as the board standards of civility, that we also have to take into account and are useful for us in addressing issues that are maybe done inappropriately or what I would consider inappropriate contact by opposing counsel. All right, let's dive over into the questions. So I'm going to open up my question panel here, and I'm hoping I've got a couple of them to make this interesting. All right, it looks like we're getting spammed. This is a new problem that I've just started to discover on the system. I've got dozens of questions in here. They're all coming from somebody's name, Mirage, and none of these have anything to do with workers' compensation. So I'll scan through here and just see. I mean, there's got to be 40 questions in here that have nothing to do with workers' comp. Okay, I'm scrolling. See if I can get to a real question. No. This has happened before where we've gotten question bombed by people. And I just think that there might be something going on where we need to block this person. So I'll look into doing that. All right. Well, I don't see any legit questions, just spam questions. So I'm sorry for that. If you did have a question and you're trying to get through and it got spammed or caught in this weird filter, please feel free to email me or call me. I'm around to answer your questions about any of this or any other topic. Some other ways to learn, just some thoughts. We have a great newsletter that you should pick up. You can sign up for that on our website. Check out my partner Christian's podcast, Third Fridays, which is excellent. Last month in September, I was a guest on his podcast, so that was a lot of fun for me. And definitely check that out. It's definitely 201 level stuff. All right, thanks for joining me today. I'm sorry the questions pane was a little messed up today. I hope there weren't any other questions. Have a great rest of your week, everybody, and I'll see you real soon.